Good morning, everybody. Thank you very much. Please be seated and please call the case.
Morning, Your Honors. The matter before the court this morning is the case entitled In Re Pederzani Administrative Appeal, case number 24-18074. Representing the appellant, Donna Pederzani, is Christian Chorba. Seated at council table with Attorney Chorba is Donna Pederzani. Representing the appellees, Ron Bliss and Kim Butterfield, is Mark Hall. Seated at council table with Attorney Hall is Ron Bliss.
Okay. Thanks very much and good morning again, everybody. Counsel for the appellant, would you come up to the podium, please? It's important to speak into the microphone so everybody can hear you, if you would, and start by introducing yourself and your client and then proceed.
Good morning, Your Honors. My name is Christian Chorba, and I represent appellate Donna Pederzani in this matter. As described in our briefing, Ms. Pederzani runs a dog rescue nonprofit called Vermont English Bulldog Rescue. Began that dog rescue all the way back in 1998, and she began running it out of her single-family home in Williston, starting in 2010. It rescues hundreds of dogs each year from kill shelters, primarily in Texas, and matches those dogs with adopting families here in Vermont. And contrary to its name, the vast majority of those dogs are not. For over a decade, there was never any opposition to the dog rescue from any of Ms. Pederzani's neighbors. There were never any safety issues, and the dog rescue never received any complaints, whether it's the town zoning office, the town manager, the town animal control officer, or the town police department. In fact, as we've described in our briefing, two of the appellees in this case and their respective families actually adopted dogs from Vermont English Bulldog Rescue.
Mr. Chorba, would you agree that the enterprise or the entity is actually a business?
So that's something that we disputed before the environmental division. However, today on appeal, our primary focus is on whether or not it qualifies as a kennel and whether kennels are a specific exception to the general prohibition on outdoor workspaces in the residential zoning district. So we've essentially, for purposes of this appeal right now, we're not arguing whether or not it is a commercial. We are, in a sense, the same.
So outdoor workspaces seems to be an important consideration in this case. Am I right?
Yes, it is.
Yeah,
it is.
Is there a definition that you would suggest to us for that?
Yes, so I would just draw your attention to some of the County Williston zoning bylaws. And what I would say is that there are really two main sets of provisions within those bylaws. There's the first set of provisions that create a general prohibition on outdoor workspaces for home businesses in the residential zoning district. After that is a more specific exception specifically allowing for kennels and acknowledging that kennels require the use of outdoor workspaces. So as to the first set of
Mr. Chorba, before you proceed, could you identify for me the specific statutory citations
of the zoning?
as you're arguing to this court now?
Yes, so that's chapter 20, section 4 of the Williston zoning regulations. And that section defines the term home business and states that no bylaw may infringe upon the right of any resident to use a minor portion of a dwelling unit for an occupation that is customary in residential areas that does not have an adverse effect upon the character of the residential area in which the dwelling is located. That particular section, chapter 20, section 4, refers to Appendix G of the Williston zoning regulations. And that stands for the proposition that outdoor workspaces and the outdoor storage of materials, supplies, equipment, vehicles, or goods for sale are prohibited in the residential zoning district, mixed use residential zoning district, and the village zoning district. However, as I said, there is a more specific exception specifically for kennels. And that comes from chapter 20, section 9. So of course, chapter 20, section 9 is after chapter 20, section 4. Chapter 20, section 9 says, first defines kennels as, quote, any space used to confine dogs, end quote. And, quote, kennels used for commercial purposes, including boarding and breeding, may be permitted as a home business.
But Mr. Torbo, what about section 3A of the standards in the appendix, which specifically states that it prohibits outdoor workspaces?
Right. So it says that outdoor workspaces are prohibited, but that is in Appendix G, which is referred to, as I mentioned, in Chapter 20, Section 4. So Chapter 20, Section 4 says, creates this rule of general applicability, and in doing so, it incorporates Appendix G. However, as you work your way through the Williston zoning bylaws, you get to pretty shortly Chapter 20, Section 9, which creates that exception. As I mentioned, while the zoning bylaws clearly, we don't dispute this, contain a general provision prohibiting home businesses from using outdoor workspaces, they also clearly contain a more specific exception allowing for kennels and acknowledging that kennels require the use of outdoor workspaces. As to that point about outdoor workspaces, one thing I didn't mention was Chapter 20, Section 9 also states that kennels must, quote, comply with the standards for accessory structures and for fences, and also states that, quote, the fencing of kennels may exceed typical height limits, but only within areas outside of the required setbacks for structures. So clearly kennels are allowed and they contemplate some form of outdoor use. One thing I would actually like to draw your attention to, though, and this is a point that I made later in our briefing, but I think it is an important point, which is that looking at precedent from around the country, it is commonplace, normal, and typical to run a dog rescue or other type of dog kennel out of a single-family home in a residential community. So Williston is not unique in that regard. I've studied a number of cases. I think I have 6 of them, but there are many more out there. I've cited to Ivanovich, which is a Missouri case that upheld a zoning board's decision to allow the operation of a dog breeding and boarding business in a single-family residential subdivision. I've cited to Williams, which is a South Carolina case that held that the dog grooming business constituted a, quote, kennel within the home occupation exception to a county zoning ordinance. I've cited Cole v. New Sewickley Township zoning hearing. It's a Pennsylvania case, and because it applied one of the 2 canons of construction that I think are particularly relevant to Ms. Pederzani's case. Specifically, that case noted that where the words of the ordinance are ambiguous, courts construe the ordinance in favor of the landowner, and it held that the language comprising a kennel is facially ambiguous and must be construed in favor of applicants as the landowners. Therefore, that Pennsylvania court affirmed the issuance of a zoning variance to operate a nonprofit dog rescue shelter.
So is that your position here? Are you arguing ambiguity in the language of the ordinance?
I actually am not. So the primary canon of construction, like I mentioned, there are 2. The primary one is this concept, and it was referred to by the Environmental Division, is this concept that specific statutory provisions trump more general ones. And that's actually a quote directly from Smith v. Desertau, which is a 2008 Vermont Supreme Court case.
But didn't the environmental court get it backwards as to which is the specific provision here?
It did. The environmental court, correctly acknowledged that particular canon of construction or principle of statutory interpretation, it actually got the analysis completely wrong. In my opinion, the Environmental Division simply did not spend enough attention or focus on which was a more specific and which was a more general. In fact, the Environmental Division's decision was, I think, just over 5 pages, and the most important part of the analysis was just a few sentences in a small footnote, maybe 3 or 4 sentences, where the court notes that the familiar canon of construction directs that where there are 2 provisions of an ordinance, one specific and one general, that address the same subject, the specific must prevail. That is correct. However, the court then, without any analysis, says, thus, while generally kennels could be a home business under the Williston zoning ordinance, and a kennel use may imply some level of outdoor operation, the specific prohibition on outdoor operation of a home business must prevail in the residential zoning district. There was essentially zero analysis of applying that kind of construction to the Williston zoning bylaws. Looking at the ordering of those bylaws, the exact language, the fact that, that kennels are actually the only home business that are specifically, stated in the Williston zoning bylaws. So kennels are the only type of home business that are specifically laid out in those bylaws, specifically mentioned.
Do you agree that the kennel restriction in the bylaws is specifically for outdoor use?
Yes, it is specifically for outdoor use. So some of those provisions that I cited specifically talk about the fencing, so that's outdoors, of those kennels.
So, is there can we infer from the language what you mean by kennels? Could it be a dog? Could it be a commercial enterprise?
It actually is, and I had quoted this earlier, it is defined very broadly. I believe the exact quote is any place used to confine dogs.
It also specifically calls out commercial purposes.
It says commercial purposes. So to your earlier question, Justice Cohen, do we agree that it's commercial? In a sense, we're not disputing that on appeal. It is a nonprofit, does not make money. It is not a profit-making venture. However, for purposes of this appeal and for the zoning regulations, in a sense, on appeal, we're just assuming that it would count as commercial. But despite it counting as commercial, like I said, the analysis is fully in favor of this dog rescue nonprofit. So I think it's actually a fairly straightforward case of the lower court, correctly pointing out that particular canon of construction. I pointed out another one that says that if there are ambiguous provisions, if there's any confusion, the confusion should essentially be resolved in favor of the homeowner. With that said, we don't agree that it's ambiguous, but if for some reason this court found that it's unclear which of these provisions is the more general, which is the more specific, very clearly based on this court's own precedent, it should find in favor of Ms. Pederzani.
Just one last quick question regarding de minimis use. Should that factor into our decision in any way?
I don't think so. Again, that's something that we argued before the environmental revision, but it's not something that we're focused on here. We believe that Ms. Pederzani is entitled to this home business permit, regardless of, even if her use is very minimal, which it is very minimal. If, we are conceding that at this stage, she would need a home business permit. And therefore, we're not arguing that there should be some de minimis exception where she doesn't need a home business permit. We are agreeing at this stage that she needs a home business permit, and very clearly she is entitled to one. If there are no more questions.
What's the remedy here? If we agree with you, where does it go? Does it go back to the town for the issuance of an administrative permit? Does it have to stop at the E-court on the way by?
Yeah, I think I would argue that it should go directly back to the town to reinstate that administrative permit.
Okay. Okay, thank you very much. We'll hear from counsel for the appellee. Please come on up to the podium and identify yourself and your client for the record. Thank you.
Good morning. My name is Mark Hall. I'm with Ron Bliss, who's representing the group of 10 or more neighbors in this appeal.
Thank you.
We have a very different view of what the ordinance says in this case very obviously, and I'll just run through it very quickly. First of all, this is a residential zoning district, the RZD. In the RZD, the only non-residential uses that are allowed are child centers, churches, elementary, middle schools, and parks. The only other use that can be there for a home business is those guaranteed by statute under 24 VSA 4413. There are home businesses that relate to the dwelling. Now, the town of Wilson has saw fit to say that in this district, yes, a home business can be operated in the district because it's essentially a residential use. However, to operate a home business in this district, you have to comply with the Appendix G, which sets forth the standards for specific standards for a home business.
But the language in the description of kennels says that it could be a home business, and that certainly isn't just using an actual residence.
Yes, but that's referring to, yes, it can, but the section regarding kennels says it can be a home business if it complies with the principles and the standards that are applicable to a home business. In this case, if we can get to it, this provision and regarding kennels is a part of a general allowance for residential uses. You can have a kennel, you can have a garage, you can have an accessory structure. However, those uses still must comply with the restrictions of the zoning district in which they're going to be landing. For example, in this case, you can have a kennel, you can have a commercial kennel where you can have dogs outside and several other districts within the town. It's only in this particular district, along with two others, in which there is a restriction on outdoor workspaces and outdoor uses.
I'd like to ask another question. The court, the environmental court held that, or ruled in your favor and said that the appellant here is not allowed to have herself or anybody who is there volunteering to help walk the dogs in the neighborhood. And I'm wondering, how does the court get the authority to not allow a person who lives in a neighborhood to walk dogs within that neighborhood?
If it's part of a business, they have all the authority in the world to restrict that. And I look at this and this is where it comes down to, you can come up with a myriad of examples.
So so are you saying that the neighborhood is encompassed in the home business?
Anything external to the dwelling is encompassed within the home business.
So the next door neighbor's yard is part of the home business?
Where if they're walking the dog through there, yes. Let me give you an example. You build a house in this residential district, put a garage in. You can park your garage there, you can do anything with it associated with residential. The minute you want to put in a auto shop, repair shop into that garage, suddenly you're crossing over into home business. Once you're in home business land, you can't be outside the dwelling, so you couldn't take those cars and park them on the side.
You do get an auxiliary building as part of a home business. That's
Yeah,
in
but
it.
you get an auxiliary building, but they have to stay within the building.
And that's because this is the RZD zone,
Yeah.
correct?
and
That's
only
why.
that.
Okay.
There are other districts in which this operation would be perfectly allowable because there's no restriction on the outdoor structures. The policy here is very obvious. Statute requires, Title 24 requires that home businesses within the dwelling are permitted in every district within the state of Vermont. However, going outside that dwelling is fair game for the local zoning board. In this case, they say, hey, we do not want businesses spilling out into the neighborhood because they're going to cause construction, which is exactly what happened in this case. The business got too big, they started annoying everybody in the neighborhood, and then they suddenly started seeking force.
What about your opponent's position of specific controlling over general? What do you say about that?
Well, in the first case, there's no reason to even go there. There's no ambiguity in statute. That's only a rule of interpretation when there's conflict in the ordinance. In other words, but in this case, I would say it's very clear from the ordinance that the home business regulations are the more specific of the two, and that's where you should start. If there's any conflict between the home business regulations and some other general use that's allowed under Chapter 20 of the ordinance, the home business requirements apply. I don't think you can read it any other way. Otherwise, you have this gaping exception to this restriction on being in the dwelling to where they could have 25 dogs. And there would be no question of what they could do on their property relative to a kennel because kennels are exempt. The term kennel is applied under Chapter 20 in residential improvements is not an exception. It's just a general use. It even says there that these uses in Chapter 20, the requirements may or may not apply depending on the dwelling's location as cross-reference. Now, if you look at the definition of a kennel, it says, yeah, the commercial kennel may be a home business, but see 20.4, which is the home business regulation. Then the home business regulation sends you directly to the.
Except the kennel language allows for fences and
Yes.
allows them to be a certain height. And so if we need to look at the home business definition that says no outdoor use of space for a home business, why would the kennel, which is also a home business, allow a fence outside?
It's obvious. I mean, if I was living in this district, and I want to have a dog and I want to have a dog house, I could do that. Now, if I start selling dogs out of it, I can't. So you understand the difference here. They're presuming in their argument that all kennels are commercial. The kennel in this case in the ordinance is just a kennel generally. And then once you get to the general versus specific question, when it becomes commercial, then it becomes subject to the requirement of.
Where does it say that? How do we make that distinction out of looking at the Williston zoning regulations, say that kennels need to be commercial?
It says in the definition in the provision that 20.9.1, an administrative permit is required for a kennel for the resident's dog. Kennels used for commercial purposes, including boarding and breeding, may be permitted as a home business.
Right.
Citation to CWDB 20.4, which is the home business restriction. And 24, as mentioned previously, deals with home business requirements that in this district do not allow any outdoor workspaces and no outdoor structure. I mean, this is about as clean as I can see. You have a circumstances where you have an ordinance that says, hey, if you're going to do home business in the residential neighborhood, it's in the dwelling. Dwelling is defined as a building.
So, but when you read the rest of that, what you just said, which talks about standards for accessory structures and fences, doesn't that include the commercial component?
No, well, it would if the commercial component could be put in a particular location. I think you're getting very confused if you're turning all kennels into commercial areas and all fences and all things associated with a resident's dog into a commercial operation. The provision makes it very clear that, hey, for your resident dog, you can have a kennel and you can have a fence and all that sort of stuff. But the minute you use it commercially, you got to go get a home business permit, which is exactly what happened in this case. And once you go get a home business permit, you got to comply with the requirements of Appendix G. And Appendix G is very clear. It not only says it has to be in the dwelling, but it cuts off the arguments made in this case that, oh, by the way, it can't be outside either. So there is no space in the ordinance to allow for a commercial operation or business of any kind, home business of any kind, to operate in this particular zoning district without, when outdoor uses and outdoor workspaces are required.
So,
Mr.
so
Hall?
let me ask a question here. It would be, if I'm understanding your position correctly, it would be perfectly allowable to have a kennel in this district where you kept the puppies for 8 weeks, they never left the house, then you sold the puppies out of the house, had another batch, you can have multiple puppies, as long as they're not outside, it's perfectly okay.
I would say yes, if they're confined to the dwelling, that it would be allowed. Similar would be allowed, as it seems to be developing in this case, it's not part of the record yet, but if she used her house for all the business circumstances involving the rescue, all the phone calls, all the billing, all the accounting, everything else, and the dog were somewhere else, I think that would be allowed. I mean, that's what we're after here, the neighbors. We don't We have nothing against dogs, we have nothing against dog rescues. What we don't want to do is have the dogs spill out in the neighborhood and the activities spill out in the neighborhood, because we have a very strong disagreement at the level to which those activities take place in reality. When we were talking 6 to 13 dogs been identified by us, many of these in the papers, 600 to 700 dogs, potentially. They've moved those dogs off site in large part, but they're still spilling back in, and it's a significant impact. And that's why I go back, the way this Williston drafted this ordinance is beautiful. I couldn't do it any better myself, because it made it, not only does it have to be in the dwelling, but we're not gonna get an argument.
Mr. Hall, is 600 to 700 dogs in the record in this case?
No, it's not.
Okay.
We have seven,
Yeah.
the court found.
You should stick to the record, I think.
Well, 7 to 13 dogs at a time, that's what we have in there.
Yeah.
But you can see the reason here why they made it so strict is it's gonna be in the dwelling, and we're not gonna give you any room to make some sort of residential equivalency or some sort of de minimis argument about the impacts. We're gonna say, no, in the building, and no, you can't use outside. Outside means external to the house, and that can be the neighbor.
You see, your argument seems to be a lot about, you haven't used this word fairness, but you know, what's good for the community and what's not good for the community. And isn't that the town's responsibility when writing its ordinances to make those sort of policy determinations, not the Supreme Court?
I'm not asking for a policy decision here, Your Honor. I think flat out the ordinance says what the ordinance said. It's clear as any ordinance I've ever said on right at this point. It said, if you want to have a kennel that's operating a business in this location, they have to be entirely within the dwelling from accessory perspective, not the outside.
And again, you're referring to section 3A, is that
Yeah,
correct?
yes.
Which specifically prohibits outdoor workspaces. It's set in the standards in the appendix regarding business activities in the RZD zone, which is where this permit is seeking.
Exactly, Your Honor. It's me as I could imagine would be written. It's almost redundant.
What about outdoor workspaces? Is that defined in the ordinance?
It's not, Your Honor. I think you just have to.
So how do we approach that? What's your position about that?
To me, if you're taking the dogs are in the back or any part of time, they're storing the dog, certainly, which is also prohibited. And if they're walking them around, that's an outdoor workspace. I mean, it's a space in which elements of the business are operated that are external to the dwelling. I don't think there's any way around that. I mean, I think I cautioned the court about trying to create any kind of camel's nose under the tent in this circumstance, because you're quickly down the road of, okay, what are we going to have this factual determination in every case as to whether this is an outdoor workspace or not an outdoor workspace, when there's no question of the fact of walking the dogs around the outside and in the front yard and up and down the street with volunteers coming to the neighborhood to do that for them, with people looking for dogs coming into the neighborhood. I mean, at what point are you draw the line, and under what principle could a DRB make a determination as well? That's sort of residential. Take that. That'll be good.
Well, couldn't they have said no commercial kennels in the RZD? Period. That's it.
They effectively did say it.
Well, I guess that's up for debate.
Well, you don't want to get into forcing the town of Williston to identify every use that's not allowed in the RZB, as opposed to doing something more general, saying you can do whatever you want as long as it's inside the house. I mean, you can understand the problems. They could say, like I'm going to say kennel, I'm going to say a lemonade stand, and that process of forcing the town to name every potential use just leads to it when some use is not on the list shows up and
But they did name a kennel. They called out a kennel.
they named kennel in chapter 20 of the residential improvements. They said the kennel can be commercial only if it complies with the home business standard. That's the full extent of the ordinance. I mean, like I said, this could be used in other locations which allow the outdoor use. It's just not in this particular location. And, it gets into things You gotta worry about what could happen. I have a garage, I can have a, oh, I'm out of time. If you want me to answer the question.
Thank you. Yeah, I think your time has expired. Thanks very much. How much time does the appellant have, please?
Appellant has 1 minute and 42 seconds remaining.
Counsel.
Thank you, Your Honors. I'd be happy to take any specific questions. Otherwise, I'd just provide some commentary on my fellow attorney's statements here. I think one thing that he did discuss was a sort of public policy argument, which we've addressed. And I think that my citation to these cases from around the country describing how tenants of all sorts, whether they're grooming businesses, boarding, kennels, dog rescues, it is very typical and normal for them to be located in residential communities, which I think is particularly important because when you look at the Williston zoning bylaws, I had already quoted this, but when you get into the section about home businesses, it specifically says no bylaw may infringe upon the right of any resident dwelling in for not being as residential areas. So we've established that, contrary to their position, having kennels in residential areas is in fact customary for all sorts of purposes. As to some of his other points, I think one thing that he mentioned was, well, he could have many dogs in his home, but the minute he starts selling them, that would infringe on the zoning bylaws. I don't think that's the case. I think that's exactly what the zoning bylaws allow for someone, say, a dog enthusiast who is breeding and to allow them to sell their dogs out of their home. And that, again, that is very normal and typical. Another example that my fellow attorney gave, this is actually in the briefing, is I believe he mentioned that if there were specific exception for gas stations, those would nevertheless be disallowed in the residential zoning district. Well, if gas stations were cited in the zoning bylaws exactly like kennels are, gas stations and fine out.
Thank you. Your time has expired. Thank you very much. Thank you both. Please